example of the concept that we have just discussed, originalism versus living evolving constitutionalism, can be found in the case Brown versus Entertainment Merchants Association, known as EMA, in 2011. I really like this case a lot because the state of California banned the sale of violent video games to minors under the age of 18. And they did so using an obscenity case called Miller versus California. They said that in their opinion, a violent video game lacks serious literary, scientific, philosophical, and other kinds of interests. And since it lacks serious interests in those areas, it should be deemed to be the equivalent of obscenity and should be banned. Well, the case was argued in the Supreme Court. The oral arguments were interesting because I think that was the oral argument where Justice Alito asked a question along the lines of, Justice Scalia would like to know what James Madison thought of violent video games. And Scalia had a clever retort. And it was pretty clear that this was going to be a battle among the originalists against the living constitutionalists. But the reason why I like my students to read it is it turns out to be a battle as well among the originalists versus the other originalists. How do they do what they do, and how do they get the result that they get? It also is an interesting case because it's new technology, and apparently, according to one account by Justice Kagan, some of the justices didn't know how to work the video game players, and it's pretty clear from reading these opinions that some of them didn't understand how video games worked. Only a couple seemed to actually have played the game. At any rate, it was a majority opinion, 7-2, in favor of free speech, in favor of the young people being able to buy violent video games and people being able to sell them to those younger people. And Scalia wrote an originalist opinion. He said the framers wanted to totally protect speech. And his argument was that the video game is a form of speech. It has a narrative, it has a message, it has elements of rhetoric in it, and it's everything that the framers and the early American people in the framing era, 1788 to 1791, would have understood to be speech. And what he does here is he begins a process of looking at what the law says and begins to ask, does that law overlap into protected speech? Now, we will turn to this later on in our discussion. But he's just saying, are there other kinds of speech like this that will be restricted if you ban minors' access to violence in media? And he begins to discuss the fact that there are kinds of speech that minors already get, they already consume, that are as violent as these video games, and that if you strictly enforce this law, you will have to also ban these things. Let me read just a short bit of his opinion. Certainly, the books we give children to read or read to them when they are younger contain no shortage of gore. Grimm's fairy tales, for example, are grim enough. As her just deserts for trying to poison Snow White, the wicked queen is made to dance in red-hot slippers till she fell dead on the floor, a sad example of envy and jealousy. Cinderella's evil stepsisters have their eyes pecked out by doves, and Hansel and Gretel, children, kill their captor by baking her in an oven. His argument is, if we enforce this law, Grimm's fairy tales cannot be sold or read to children. And then he goes on to say, have you seen cartoons? Have you seen movies? They are also just as invasive. So Scalia's version of the First Amendment is dictated by the original founding era public wanting to get as much access to literature and messages as they possibly can. All such literature will be protected. He argues in a different way than Clarence Thomas. Clarence Thomas does not look at the kind of material that Scalia looks at. Instead, he looks at the newspapers and the writings of that era. And he concludes that the founders didn't actually protect the speech as it would get to students, but they had another goal in mind. Here is Thomas's version. In my view, the practices and beliefs held by the founders reveal another category of excluded speech, speech to minor children bypassing their parents. The historical evidence shows that founding generation believed parents had absolute authority over their minor children and expected parents to use that authority to direct the proper development of their children. It would be absurd to suggest that such a society understood the freedom of speech to include a right to speak to minors or a corresponding right of minors to access speech without going through the minor's parents. So he has used his version not so much of the Declaration of Independence, inalienable rights, but more looking at the newspapers of the time to say, if you want to sell something to children, you need to get the parents' permission to do that. And so he's actually dissenting from Antonin Scalia on this issue. Now, when you look at their debate on the differences of the original meaning, you should also look at the competing opinions of Stephen Breyer and Samuel Alito. It is clear that they have played the game. It is clear that they understand that the immersive nature of a violent video game is very different from using your imagination when you are reading Grimm's fairy tales. You see all the violence coming at you. You participate in the violence in the game. You are part of that world. And both men, although they disagree on how they will come out in the case, both men say, if I look at this law, the law is too broad. You need to tailor the law so that it only regulates the bad conduct and does not regulate good speech. So their argument is, you need to look at the demonstration by the government of the harm that results from these games. You need to prove that a child who plays a lot of violent video games may become more sociopathic, may become more dangerous, may become more damaged. If you can't prove the connection between the result of the speech and the actual speech, which they say isn't in fact speech, it's actually a form of entertainment and a game and should be seen as such, then you haven't properly decided this case. The fun of this case is to see that what they're all debating is whether you can carve certain kinds of expression or narrative or speech out of the First Amendment. And can you rule that governments can ban it? And there are different uses of social science, of analysis of the law, textualism, and their different uses or non-use of history leads them to four very different kinds of opinions.